then I'll bring them another drive or I'll download it from eDiscovery. But
Okay,
I'll make sure that there's no issues.
all right. And Mr. Cepeda, I'm not the one who set the bond in either of these cases. But what I want to tell you is sometimes with the GPS.
Like Jill from hand sanitizer.
All right. Hello. You're in the center and your attorney's on this side. So you're Eric Cepeda?
Yes, ma'am.
Right. Thank you for dressing appropriately for court. All right. So defense, I have this motion to reduce bond. Of course, that's
It's just waive fees. The reduced bond was, I forgot to cross it off on the original copy. It's just waive fees.
all right. So it's the waive fees of the GPS?
Yes, Judge, that's all we're asking.
All right. So with regards to waiving the fees of the GPS, because he's not in custody, I'll need to take some testimony.
Okay.
And Mr. Cepeda, that testimony will solely be related to your ability to pay the GPS fees. Do you understand?
Yes, ma'am.
All right. And Cindy, let us know when you're ready.
Okay, I should be okay for now. I mean,
Okay.
I have 1 minute, Judge. Just-
Sure.
Let me talk to you 1 second.
All right, sure. Hi, how you doing?
How are you?
All right.
I mean, I'll send her to the court. I signed, I
But I didn't have-
I crossed up the reduced fund everywhere except the title, so I don't know. I just-
Yeah,
Okay.
and that writ that we filed in the motion and all
Oh.
that stuff. Microphones.
Oh, let me just tell you, I don't even have any of that. This is the
Okay,
only
okay.
thing that I have.
Perfect. Yeah,
Okay,
all that, we don't.
So
need to
we'll
be
go
able
with
to do
this.
any of that, except for the motion to reduce.
okay.
You want to do it?
So just, is it working now, Cindy?
Yeah, I'm good.
Ah, okay, it's working. Do you
Well,
still need
there's-
IT or no?
Yes, there's a couple of them that aren't working, but one's working for now for you to do this.
All right, this should take 5 minutes. Or maybe 8. All right, the court is calling 2025 PF 07201, State versus Eric Ray Cepeda. Can I have parties announced for the record? State?
I'm sorry, Judge. Jason Garahan for the state.
Good morning, Your Honor. Daniel Del Garza and Charles Bunk for the defendant.
And are you Mr. Cepeda?
Yes, ma'am.
All right, so defense, you did have a motion to reduce bond. That's moot because your client has made bond.
Yes, Your Honor.
So now you're before the court and you're asking that GPS fees be waived. Is that correct?
Yes, Your Honor.
All right. Do you have any witnesses with regards to the waiver of the GPS fees?
Yes, Your Honor. For the limited purpose of this hearing, we would call Mr. Eric Cepeda.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Say what, ma'am?
You may lower your hand, state your name for the record.
Eric Cepeda.
All right, so this hearing is solely to determine whether or not you're able to pay your GPS fees. Do you understand?
Yes, ma'am.
All right, defense, you may ask your questions.
Thank you, Your Honor. Good morning, sir. And you're the defendant in this case, right? Okay,
Yes, sir.
and just let me ask you, you are on bond in this case, right?
Yes.
And are you wearing a ankle monitor?
Yes.
It's a GPS monitor, right?
Yes, sir.
And there are fees associated with that monthly, is that right?
Yes, sir.
And are they $300 a month?
Yes, sir.
And are you working right now?
No, sir.
Were you working at the time
No, sir.
that you were arrested?
No, sir.
And do you own any stocks or bonds?
No, sir.
Do you own any real estate?
No, sir.
Do you own a car?
No, sir.
Do you own anything of value that can be sold?
No, sir.
Do you live with your parents right now?
Yes, sir.
Are you on full house arrest?
Yes, sir.
And do you solely rely on your parents for shelter
Yes, sir.
and food
Yes, sir.
and monthly expenses?
Yes, sir.
I'll pass the witness, Your Honor.
Any questions?
No questions from the state, Your Honor.
All right, I just have a few questions. When were you released from custody? Defense, do you know when he was released? Just approximately.
About a week, Judge.
And how old are you?
17, ma'am.
All right. All right. And you're on full house arrest.
Yes, ma'am.
And since you released, have you tried to seek employment over the internet or anything of that nature?
No, ma'am.
Okay. And have you previously been employed?
No, ma'am.
All right. Then if there is no other testimony, the court is going to grant the motion to waive GPS fees. All right. Anything, any other motions?
That's all we have on this issue.
All right. So of course, this case has not been indicted. And the reason why I said it is because of the nature of the case. I wanted to make sure, and I know with the attorneys that are on each of the defendants' cases, there will be communication, but I wanted to make sure if there's any issues with downloading anything such as videos or if there's going to be a cell phone dump, we can go off the record that communication is constantly open. So, defense, if there's any type of issue with something you can't download, please, I know you all wouldn't, but please don't wait till the last minute to say, I can't download this.
No, Your Honor. No, we've both known Mr. Garahan a long time. I'm pretty sure we even have his phone number. So if there's any issues like that, I'll text him or call him. And what I typically do on these cases is I just bring them a big old drive from Costco with 4 terabytes or whatever. And I just ask them to throw everything on there. And if there's anything that needs to be supplemented, and I did this as recently as this week.
Okay.
Then I'll bring them another drive or I'll download it from eDiscovery. But
Okay,
I'll make sure that there's no issues.
all right. And Mr. Cepeda, I'm not the one who set the bond in either of these cases. But what I want to tell you is sometimes with the GPS, people will say, my battery is running low or something's wrong with the GPS. You need to stay in contact with your pretrial services officer. And if there's an issue with the GPS, you need to let them know beforehand there's an issue. Because if I receive pretrial services notices that they've lost contact with your GPS because of the nature of your offense, I'm going to sign it. And then we can have a hearing later, of course, about what happened, but don't let it get to that point. You understand?
Yes, ma'am.
All right. So this is what I'm going to do on this case. I'm going to reset it for May. So if you all can look on a date in late May, that is good for everyone. And again, it's just to see where we are to make sure information is still flowing, which I know it will, but I just don't like cases to be out there and nobody's had real contact. Okay.
Yes, Judge.
So just let me know what date would be good for all parties. And Jason, I know you have capital murders that are already pending in murder cases. So if May is not a good date to bring this back, if June would be better, just let the court know. And guys, since this is a case where it's 3 co-defendants, and that really puts a strains on the deputies because they have to keep them separated. Deputy Laura I'm sure Friday would probably be best, or Wednesday, Friday or Wednesday, as opposed to bringing them on a Thursday or Tuesday where there are a lot of people.
Right, Judge said Wednesday or Friday.
21.
May the 21st, Judge.
All right, so Ms. Ferguson, this is going to be called for May 21st, and we'll just set it as a discovery.
Excellent.
All right, is there anything else from either side?
Not from the state, Judge.
No, Your Honor.
Do you have any questions about anything?
No, ma'am.
All right, once you sign the reset form, you'll be excused. All right, thank you. Thank you. Oh, you can have a seat. They'll bring a reset form to you.
Judge, thank you for reviewing and signing my proceed orders.
All right, you're welcome.
Have a good one. All right, let me know.
Hello, you are Roberto Monreal?
Yes, ma'am.
All right, so the reason why I set these cases was because the nature of the offense, and I just want to make sure that communication is open between the state and the defense. And I know both of the attorneys, I'm sure communication will be open. My understanding from the other 2 defendants that were here is there is a lot of discovery and there are some downloads. So if there needs to be a drive or something turned over to state, just make sure that's done.
Yes, Judge, and just for the record, if I can do that with Jason, the only thing we have on our discovery is the affidavit in support of the arrest warrant still. That's all we've got.
Okay.
Jason just gave me this today. It's all single space, teeny tiny. There's no way I can read this morning and
Oh, no, I'm not expecting y'all to. I'm just trying to make sure that discovery is given. So.
well, and we
I
also
know
have a
we'll be
motion to
given.
reduce bond. But I, in talking to Jason and looking at this, I think it would be in my client's best interest to push that to another day so I can argue this more intelligently than I could today.
No. I'm having people come back on May 21st.
Is that okay?
That's the same date as the co-defendants are sent.
Yes. And on these cases, I have to set it either for Wednesday or Friday because it's difficult for deputies to bring inmates over there on a regular docket because of the nature of the offense.
I think one of them is on bond. I don't know
One
about
of them may.
Yes.
the other. I
Just
mean,
aware of that.
isn't it better to have them not set on the same day in terms of being able to bring them out?
No, because then that makes it difficult for the state and it makes it difficult for the deputies to keep up with everything. And then if this ends up not being a dismissal or an agreement, but ends up being a jury trial, the coordinator likes to have them set together so that everyone can get a similar date and time. All right. Do you have any questions, sir?
No, Your Honor.
All right. So we'll bring you back on the 21st. And defense, if you have any motions that you would like filed, just confer with Ms. Ferguson and she'll put it on a date.
Yeah, you already signed my expert motion, but Monica filed a while ago the motion to reduce bond. So at some point, I think before the 21st, I would like to have a hearing on the motion to reduce bond,
Oh,
if
just,
that's possible.
yes,
Yeah.
just confer with Ms. Ferguson on what date you want it on and we'll get that on the a
Okay.
date before you all leave. But the discovery date is still going to be May 21st.
You're gonna have everything to do.
No, it's not, it's ongoing discovery.
Okay.
Yes,
I mean,
I can bring you a hard drive.
that's fine.
I mean, and again, I mean, I think everybody's aware that this is still on the intake level. and
Yes.
I'm not in possession of the file. I just printed out the main report.
I know that I spoke with Laura Metzfold or
Metzel, yes.
a couple of weeks ago, and she said that Detective Graham was gonna bring her discovery and it would get uploaded, and since nothing's there, I'm assuming that hasn't happened yet.
Yes. And then if you both can confer, if you all are expecting me to hear the bond, if you all can confer on a date so that everybody
I
can
need
be
to
ready.
talk to Monica to make sure she's available too.
Okay,
And Judge, just let you, I mean, I want to make sure, there is a co-defendant that is in juvenile. Just to let everybody be aware.
okay, Alright.
So there's 4 total.
all right.
I'll get that information. Okay, thank you. Judge.
It's in there.
I'll get, well, I was gonna see who the lawyer was, but I'll get a date from Norma as soon as I talk to Monica for the
Uh-huh.
motion to her bond. Okay.
All right. All right, thank
Thank you,
you.
Judge.
Thank you. You're welcome. All right, with that, they will take you back. Suzanne, do you need to speak to him anymore?
Do you have any questions of me right now? I did speak to him very quickly before. Monica's been mostly the one, that's the task I assigned her, so she's been Zooming and ICSing with you.
Yeah.
So I think we're covered on that.
All right, thank
Okay.
you.
Thank you, Judge.
Thank you. You're welcome. All right, court is calling 2024 CR 010008, State versus Nicholas Cameron. Can I have parties announced for the record?
Scott Hill for Mr. Cameron.
Are you Mr. Cameron?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Mr. Cameron, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, waiving the habitual offender enhancement allegation.
Any objection?
No, Your Honor.
Did you review admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
No.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Cameron, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Sure.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea bargain agreement, punishments be assessed at 180 days in the Bear County Jail under 1244. And there are no applications. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
No.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there been any such motions?
No, Judge.
Then to the offenses charged, how do you plead?
No contest.
State any evidence.
Should be contained in Exhibit 1 and attachments, Judge.
No objections.
Right, state you may be excused.
Thank
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call on, the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
No.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, I've spent a lot of time talking to Mr. Cameron, just trying to give him some counsel on some programs he can try to go after he's released from Bexar County Jail. He's going to go stay with his mom, who's here out in Elmendorf. Elmendorf. Judge, he's been in custody for, I don't know the exact day, but it's been over probably 7 months. I don't think it's quite 9.
Almost 9.
Almost 9.
Yeah.
So he's been in jail for a long time. He knows, he knows he's got to stay away from the drugs. And he knows that's an issue for him. So he's going to do his best. So I'm just asking the court to follow our plea bargain agreement.
All right. The court will find you guilty as previously stated, sentence you to 180 days in the Bexar County Jail under 1244. Give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. How old are you?
41.
All right, so here's the thing. You're getting to that point where time is going to go by so quickly for you, and you're going to have to start making decisions. Do you want to spend a majority of your time in jail or in prison? That's completely up to you. It's obvious that you have a drug problem. If you don't get that resolved, what's going to end up happening is either you're going to end up in jail or somebody's going to end up identifying your body. And I don't think you want your mom to have to be the person to have to identify your body in some field somewhere. You understand? But at the same point, if you're not prepared to live life truthfully and openly, where you're trying to improve yourself by becoming clean and sober, then don't visit that on your mother's doorstep. Just send her letters. If you want to be dishonest and say, Mom, I'm doing great, then do that. But don't let her have to see you continue to use over and over, because then that's burdening her, because she has to provide tough love for you, which usually mothers don't want to do. When they see their child hungry or they're not doing well, then a good mother, then they're not doing well if their children are not doing well. So you're going to have to make decisions. There are plenty of programs in San Antonio. There are plenty of programs in Elmendorf that can help you. But in order for you to be successful, you're going to have to change people, places, and things. And the only thing you should be doing is going to work and going home, and nothing in between, unless it's sober support meetings or some kind of treatment. You understand?
Yes, ma'am.
All right. Good luck to you. Okay.
Okay, thank you.
You're welcome.
Have a good day.
You too.
Thank you, Judge. May I be excused?
Yes. Is there anyone else? All right. And this is Gabriel Echartia.
Yes, ma'am.
All right. Let me just put this in the system, then we'll go on the record with this. And is Edelman going to be on this?
I'm sorry.
Is Mr. Edelman?
I spoke to Jason about it. I didn't speak to Mr. Edelman. It's a motion to set bond.
Well, if you want to speak to him about it, or let him know what your agreement, if you have one, with Jason was.
Good weekend, Judge.
All right, you too.
I know.
Bashan. On this case, I believe he's on deferred adjudication. Can you, let me see if I have a copy of the motion to revoke.
Sounds about right.
Okay. Oh, I think I see it in here. All right. We're going to go on the record. And Mr. Echatia, could you unmute your, thank you. The court is calling 2024 CR 1497 State versus Gabriel Paul Echatia. Am I pronouncing your last name correctly?
Yes, ma'am.
All right, thank you. Oh my gosh, that's shocking for me. Okay. Could I have parties announce state
Andrew Harris, Edelman.
defense?
Jesse Sepulveda for Gabriel Paul Edchartea.
And if you could state your name for the record, sir?
Gabriel Paul, each right there.
All right. So your client is appearing by Zoom. Any objection to us having this hearing with your client by Zoom?
No objection, Your Honor.
All right, your defense counsel has filed a motion to set bond in this court, the 187th District Court. You're on deferred adjudication, so you're entitled to a bond. The only question is what the amount will be. Have you all discussed an agreement with regards to a bond?
I discussed it with Mr. Edelman as well as Jason Garahan, and they are recommending $10,000 bond, Your Honor. I believe the original amount when Mr. Edchartea was originally arrested was $5,000.
All right. And the court, due to the fact that your client is on deferred adjudication out of this court, the court is aware of any type of prior substance abuse issues. But there are a few questions I would like to ask you with regards to your status now. If you could raise your right hand for me, please. Mr. Yes. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. And if you'll state your name for the record again, please.
Gabriel Paul, each right there.
All right. How long have you been in custody in the other county?
About a week, ma'am.
All right. Since that time in custody, have you been placed on any type of mental health division of that jail?
No, ma'am, but they have requested and asked me if I would like to, and I denied.
All right. And so you're not on any type of medication?
No, ma'am.
All right. Then what the court will do, the court will follow your agreed bond recommendation of $10,000. I'm going to order sober support meetings as a condition of your bond. And I'm going to require 30 in 30 days. And then we are going to set this for a hearing. We can go off the record. State, what is the status of the allegations in the motion? I think there is a number 1 with regards to reckless driving. And it's in Bear County. Would you have that police report?
No, Judge.
All
I
right.
might be able to look it up if you'll allow me to.
Yes. I just want to make sure that you have what's needed, and then I can give you all a setting.
Thank you, Judge.
And is he only there because of the warrant here?
I believe so. Is that right, Gabriel?
Yes, sir. And yes, ma'am.
Okay.
Judge, if I may, I was just retained a few days ago, but from what his mother has told me and his brother told me, apparently Gabriel was a complainant on a case. He was stabbed 4 times by some other individual, I think a boyfriend of one of his ex-girlfriends.
Mhm.
And I'd like to, I guess, just be given some time to inquire about that, because she says he's not the same individual, that he's had some issues afterwards, and I'm not sure if he's seen a psychologist or psychiatrist, but apparently it was a traumatic event for him.
Okay.
Is that right, Gabriel?
Yes, sir. I haven't seen a psychiatrist or a psychologist after the stabbing or anything. They recommended therapy through the state. The state was providing it, but after a while they started charging, so I couldn't afford it.
And then Ms. Ferguson, if you can bring this back the week of April 14th. Right. So
I think I had something in the juvenile on April 15th, on that same week, 14th. Yeah, can we do that?
all right. So your case is going to be recalled for April 14th. You should be released. If you are released, you need to be here at 9 a.m. Do you understand?
Yes, ma'am, I understand.
All right. Is there anything else, counsel?
No, Your Honor. Thank you.
All right. Thank you.
And be excused.
Yep, you may be excused.
Good week.
All right. And sir, you can let the deputy know that your hearing is complete. Your attorney will probably get in touch with you or get in touch with your family to see about your release.
All righty, thank you, ma'am, I will.
All right, you're welcome. Oh, and Jason, on your way out, if you could tell Charles we're ready on this case, Curtis. All right, thanks.
You said call.
All right, thank you. Thank you. And do y'all have the updated docket?
So.
Okay. Okay. Have you found him? Do you know where he is?
Have not particularly looked for him to see what.
Okay.
Hello.
Good morning, Judge.
Good morning. How are you doing?
All right.
Oh, all right. How's the oatmeal coming along?
I knew you would ask.
I tell you, I do the oatmeal. And when I was in, I learned how to do it very well on the microwave when I was in a hotel. So,
Okay, so my big deal now is the lemon water and the cucumber
briefly-
water.
oh, I love that.
So what?
All right. I'm gonna add the lemon to it. I had just been doing cucumber, but I'm gonna add the lemon to it.
And if you put them together, it's even better.
Okay, all right. I'm gonna do it. All right, so who are you here for?
Judge, I'm here. I was conferring with Andrew on a case that is set on Tuesday morning on Jose Rodriguez Perez. He's in federal custody in Del Rio.
All right, so if you have them, if you'll go in the back and tell them to pull the file for me, and I'll take it up.
All right.
And just let me know when you all are ready to proceed. Yes. Yes.
Mr. Rodriguez is in federal custody. I do not represent him on that matter. He is in Valverde, the Valverde Detention Center.
Okay.
And an investigator from the public defender's office contacted me and notified me that it's going to be somewhere, he's there on an MTR, what we call an MTR. He will be in custody anywhere from 4 to 10 months, followed by 26 to 32 months of supervised release. So his hearing isn't going to happen anytime soon. He's set for Tuesday, and I'm conferring with the state to see if, in the interest of justice, they might consider dismissing this case, but we don't have an answer yet.
All right, so state, you'll have to look into that.
I will, Judge.
And
My
then-
concern bringing it up is if he's not going to be able to be physically present on Tuesday, and we'll reset this case and say.
No, we're gonna reset it, but I don't want us to be back here in 3 months and this state jail felony is still pending. So looking at it and see if y'all are having plans to dismiss it or not.
The judge, I just want to save defense counsel a trip if it's
Mhm.
not necessary.
Okay. All right, so what I'm gonna do, and state you need to have a decision made for the defense. I'm gonna recall this, and you said what date was originally set on?
It's set for Tuesday, the 25th, next Tuesday,
All right, so I'm gonna recall this for May 27th.
27.
Yes.
I'll put it on my calendar.
All right, and the state will have an answer for you by that time.
Okay, May
Yes.
27.
Yes, May 27th.
Thank you, Judge.
You're welcome.
Thank you.
You're welcome.
But your friend, well, I forgot we're streaming, so I'll tell you, I'll talk about it later. One of
Okay.
your ex-clients is giving me fits,
Oh,
but she loves you,
all
talks about you fondly all the time, and I think you should step off the bench and handle this one.
okay.
Take a week off and
Okay.
go over to County Court 12 and handle the matter for me. So October.
Ms. Ferguson, Mr. Cox is here. And Deputy Laura, is his client here? If you could have him brought out. Oh, no, let's not do that. No, there was notice.
Anybody. My secretary, my legal assistant. Anyway.
I'm like, where's my drink? I could have sworn I brought it in here.
All right, are you all ready to proceed on Mr. Curtis?
I think so.
All right, court is calling 2019 CR 10230 State versus RC Curtis. Could I have parties announced for the record?
Darrell Harris for the state, Your Honor.
Charles Buck for Mr. Curtis, and let the record reflect Mr. Curtis is present on Zoom. Thanks to the court and Mr. Harris for that courtesy.
And defense, you have no objection that Mr. Curtis is by Zoom?
I do not.
All right, so we're here. Detective Hines is on the stand. Detective Hines, you're still under oath. There are some documents that Detective Hines brought with him. It's 22 pages. Defense, are you in receipt of that document?
Yes.
All right,
Or
and it's,
documents plural.
yes.
But yes, I am.
All right. And my understanding, this is the final documents that need to be reviewed for any more discovery issues. Is that correct?
I hope.
Yes, sir. Echo counsel's sentiment, but Your Honor, yes, on my notes from our last setting, the opening questions regarded the collateral witness Antonio Jones in his July 2016 arrest, specifically whether in his personal property there was an additional cell phone. My understanding of the documents, the detective.
All right, so let me just stop you. So these 22 pages that was given to the court, Mr. Bunk has those.
Yes, ma'am.
All
Yes,
right,
Judge.
so the witness is under oath. With regards to these 22 pages, are there any questions from the state or the defense with regards to these 22 pages of the witness?
Yes, Your Honor, I could be fairly quick.
Oh, no, ask questions. He's here.
Detective Hines, and were you able to check with the property room as it relates to the July 2016 arrest of Antonio Jones?
Yes,
Did they have any property of his, and specifically, did they have an additional cell phone that you had not seen or inspected?
no, they didn't have any record of what property he had when he was booked that day.
Right, and to your knowledge, are there any additional cell phones attributed to Antonio Jones that have not been inspected or downloaded?
Not that I know of.
You were also tasked to run the registration of the vehicle occupied and driven by collateral witness Scotty Perez on his related to his 2 municipal court citations. Did you run the registration for those vehicles, and is that contained in the 22 pages you've brought to court today?
Yeah, I ran registration on one vehicle and I did bring that to court today.
And is that the same vehicle as over the 2 citations?
Yes.
I have nothing further, Your Honor.
All right, defense, any questions?
I'll start with the email. This indicates the records of what personal property came in with this. There's no record of what personal property came in with Mr. Jones at the time of his arrest. Is that correct?
That's correct. Yes, sir.
And would you agree with me that, and I think we have, in fact, I know we have from previous meetings or hearings, the offense report that has the case number 161581115. That's the same offense that's referenced in this email. Is that correct?
Yes.
Okay. And that's the arrest. That's the incident where Antonio was arrested, correct?
Yes, sir.
Okay. And so, and do you have that report there with you still from?
No.
Okay. May I approach Judge?
Yes.
I'll just stand. May I stand and we'll just look at it together?
Yes.
Okay.
Mr. Cox, if you wanted to speak to him, you can.
So Detective.
Just 1 second,
Okay,
sorry.
no worries.
Deputy Mejia, can you move him to the back row?
Yes, Judge.
All right.
We're gonna look at just together what I'll mark as, oh boy, defense. I don't even know. Defense. For the purpose of this hearing, I'll mark it as defense 1A.
I think maybe it would be best, because there have been many that have been marked. Are you sure that 1A would be the number? All right, then let's do it this way. Mark it as 1/March 21 for the month of March, and it's the 21st day.
I'm sorry, so is that a good defense?
Yes, defense 1/March 21.
1/March 21.
Yes. And that way there'll
Okay.
be no confusion with the record.
I'm going to show you what I'm marking as defendants 1/March 21. Okay?
Okay.
And it seems to be an offense report with the offense case number 16158-115.
Mhm.
That's the same report number as in the email. Is that correct?
Yes,
Okay. And you and I went over this at the last hearing. I'm not showing you something we haven't talked about before, right?
okay.
Is that correct?
If you say so.
I'll let you look at it. I'm not trying to trick anybody.
Okay, yeah, this is a offense report written by Officer Andrew Tran.
And take a second and go through it. And is that in fact the offense report that relates to the arrest of Antonio Jones that is referred to in the email we're talking about now?
Yes,
Okay. And in this report, are there items listed that were taken from Antonio at the time of his arrest?
yes,
Okay. For example, there's a handgun.
yeah,
There's a handgun on page 2 of this document, or excuse me, page 3. It talks about property and items. There's possible heroin
Mhm.
and a handgun placed in the property room. That's not, so when it's placed in the property room, there's 2 different handguns based on the serial numbers, correct?
yes, sir, it looks
Okay.
that way.
And when it says placed in the property room, that's different than what we're talking about in the email, because the email
Yeah.
refers to personal
Personal
property.
property, yes,
Okay.
sir. Mhm.
And so there's nothing else as far as there's no other personal property listed on this report. Is that correct? I'll just let you look through it. I didn't see anything, but I'll just let you look through it. As far as currency or telephones or
No, sir.
okay. All right. Now, when an individual is actually booked into the jail, there's a process there. He's processed, correct? He's fingerprinted. Is that correct?
I don't know, sir. I don't work at the jail. During the booking process, back when I was a patrol officer, we would hand them off at the detention center and turn in whatever we were charging them with to the magistrate and turn in whatever personal property they had is what we're talking about right now. The jailers would take and put it in a separate bag.
All right, and I'm sorry to interrupt, counsel. If we could just take a brief recess and let me handle this case. Mr. Cox, are you ready on your client? All right, if you all will step down and Cindy, this is not going to be on the record because I don't believe they have any motions. Yes, please.
In the middle.
All right. Hello, Mr. Cox. All right, so on this case, Mr. Camarel, the reason why I said it is because the nature of the case, I want to make sure that there's communication going back and forth between parties. So, Mr. Cox, if you have any motions that you want heard, just set them with the coordinator and we will hear it. I'm trying to keep these cases on Wednesdays and Fridays because it's hard for the deputies when we have a full docket and then there are certain inmates that need to be separated. So we've decided previously to bring this back on May 21st. Are you available with that date?
Yes, sir.
All right, so we'll bring this one back on May 21st as well. You may need a hard drive. I don't know if there are phone dumps in this case or not, but I'm sure there will be a lot of evidence.
Let you know, Judge, yes, there is.
All right.
And
So,
just for the record there, on the, my
IT person,
Mhm.
Angel checked, and the only thing they had, the only, have discovery that appears in the, online for us, the portal is the arrest affidavit. That's all.
Mhm.
So I've gotten nothing other than the arrest affidavit, so I don't know how quickly those things are gonna be.
I checked out yesterday and at least I don't remember which one I looked up, but I mean, we do have reports on there. That's, I made copies of that. So if you would like to bring a hard drive, I mean, I could get at least, or I can make a copy of the sort of the packet of the prosecution, the detective handling it. It's out of Selma, Judge, so it's a little different, but I mean, I can supply
Okay.
that to you if you like.
That's fine.
All right. And if there are some issues with discovery, as I was telling the other attorney, I know the attorneys on this case, so I knew you all would communicate. But if there is some issue that discovery is not being delivered from Selma or wherever it may be, that's what we'll be having these hearings for, to make sure everything is going well with discovery. So we're going to be back on May 21st. Mr. Camarel, do you have any questions? All right, so we'll bring you back on May 21st. And Mr. Cox, if there are any motions that you wish to have heard, just let the coordinator know,
Thank you.
and we'll put it on the docket.
Thank you, Jim.
Thank you.